Hey everybody, and welcome back to this edition of the Multifamily Investing Academy's Masterclass Elite Group Coaching Call. This one is on putting together your real estate limited liability company. And as I always start, let me just start by giving you the old disclaimer. I'm an attorney. I am not your attorney. Hire an attorney, and everybody thinks that they know. That's all I say, but this time I'm saying this. Lawyers love LegalZoom. Now you might think to yourself, well, what does that mean? Well, the fact that we're going to be talking about limited liability companies today, and you see all these advertisings about how you can start your LLC, by just contacting LegalZoom, and you think, oh, geez, all these lawyers are losing all this money from not drafting limited liability companies. Well, the fact of the matter is that litigation is a lot more expensive than drafting. And I have seen some doozies when it comes to operating agreements for limited liability companies that are created by these types of websites. Now, I know you're all thinking, well, you're a lawyer, this is what you're supposed to say. Now, I'm not kidding you, folks. I've seen some doozies. And as a matter of fact, I'm involved in an action where the partners are suing each other, and one of the partners thought he was the smartest guy in the world and decided he was going to draft the operating agreement, and it's proving itself to be a huge disaster. So it's a lot less expensive to have an attorney draft your documents than it is to have your attorney litigate you out of a problem. So that's why lawyers love LegalZoom, but being penny wise and pound foolish, and you'll be paying your lawyer a lot of money. So let's talk about today's objective. Today's is understanding how to set up your limited liability company. But more specifically, what I really want to talk about in this is the limited liability company that owns the property. Okay, now this is important that you understand this. You can have, I see, Manish out there, Manish LLC. Well, that is the company that Manish and his wife own together, and that they're going to hold all of their real estate assets, their membership interests in that LLC. But what we're talking about today is not that LLC. We're strictly talking about the LLC that owns the property that we have just gone out and got under contract and are raising funds for and are looking for investors for. That's all this discussion is going to be all about. All right. So let's talk first off. One of the things I want to throw in this little caveat here about piercing the corporate veil. We'll get a little bit more into this later on in the conversation, but I want you to understand this particular term. The reason why we set up a limited liability company is to limit the liability. But if you treat the LLC like it's your own private checkbook, like it's your own little fiefdom, and you don't follow the terms that you've drafted in the operating agreement, which we'll get more into in a moment, then if you've done something wrong and you're trying to hide behind the limited liability company or that corporate veil, if you haven't treated this company, treated this entity like it's a real entity, then a court could come behind it and pierce that corporate veil and get to you personally. So make sure that you do all the things that you're supposed to do with a limited liability company. Draft the right documents, have the meetings, have the minutes of the meetings. Make sure you file with the state, and not only file with the state, but renew your filing with the state every year. That if you fail to do that, that could be perceived as that you're not, looking for that LLC protection, and therefore a judge could go in there and pierce the corporate veil. Judges don't like to do that, but we're already seeing some case law where judges on limited liability companies, because they're so easy to create, because everybody's trying to hide behind them, judges are being more inclined with the right amount of evidence to go in and pierce that corporate veil. And you don't want to be that common law, that case law situation where you are now known as the guy who got your LLC pierced because you did something wrong. All right, so what is a limited liability company? Folks, I don't want to sound like I'm ancient or anything, but when I was in law school, LLCs didn't exist. Well, the fact is they did exist, but they didn't exist in the state where I went to law school in Massachusetts. So we didn't even need to know this. This wasn't even a class in law school. This wasn't even something that we had to have on the bar. That's how new limited liability companies are in certain areas. So a limited liability company is what I think is one of the best vehicles available to creating a company, a limited liability entity that you can use in real estate. It's kind of a hybrid. It's really a hybrid between other types of entities. Now, we've talked about other types of entities. We all know what other options you might have. You've got an S corp, you've got a C corp. Well, actually, let me back up a little bit. You've got corporations, and then the tax choices of those corporations are either an S corp or a C corp. But the corporations are a form of an entity. That's an option for you. A partnership is another option for you to enter into business and create profit. A sole proprietorship is another option for you. A limited liability company basically takes the three elements, the best elements, I feel, of those types of companies and merges them all together. And that's why the LLC has taken off as a vehicle for new investors. For example, with a corporation, the benefit of the corporation is you've got that limited liability. So do you with the LLC. And the partnership, one of the nice things about a partnership is it acts as a pass-through vehicle for your taxes. There isn't double taxation. The same is true with the limited liability company. And then also on a sole proprietorship, the limited liability company, or the benefit of a sole proprietorship is it's easy, it's nimble, you can manage it very, very well. The same is true with the limited liability company, and I'll get more into it in a moment so you can see different ways that you can really design the company to your benefit. Now, one thing I want to talk about, and this is, I just got through saying that limited liability companies were a relatively new entity. Series limited liability companies are a really new entity. This is the new thing taking hold that you might want to think about. And if you're starting your real estate business now, you might want to think about using a series LLC. Now, what does that mean? You're going to have to find a state that allows for series LLCs. Not every state has taken this on yet, and I bet some states will never take it on. Like take, for instance, Massachusetts. I cannot set up a series LLC in Massachusetts, but I would have to go to Delaware and set up my series LLC in Delaware. And let me explain to you how it works, and I'll explain to you why I think Massachusetts will never do it. A series LLC is essentially a parent entity, a parent LLC, and below it are what we call sister LLCs. So every time Manish LLC goes out and he buys 123 Main Street, he can set 123 Main Street up as 123 Main Street LLC, a sister LLC of Manish LLC. So under Manish LLC, every time Manish buys a property, he can set up a new LLC. Same tax ID number. He doesn't have to go to the state and pay another $500. And when he's done with that LLC, when he sells that property, Manish LLC still remains in good standing, and he can proceed forward. He doesn't have to deal with 11 different LLCs. He can just deal with filing for one. Okay, I just got something. Someone just asked me the question. Diane Kennedy has changed her mind about suggesting series LLCs. Do you have any concerns? I don't know who Diane Kennedy is, so I have no concern whatsoever. Yes, if somebody wants to give me a little bit more information on that, I'll be more than happy to delve into it. Like, why does this Diane Kennedy feel differently about series LLCs? One of the things I was just about to say why I don't think it'll ever happen in Massachusetts is to set up an LLC in Massachusetts, you got to pay $500 every single year. You imagine having 10 different LLCs where you're just paying them $500 to get the benefit of that protection. You can go to different places to get that same type of level of protection without having to pay $500. I'll explain that more in just a moment. So Now, let's talk about what you have to do just initially from an operational standpoint in order to get your LLC. First thing you have to do is get a name. You got to go figure out, what am I going to call this company so that it doesn't look just like another company that's already registered with the state. So for instance, if what you're going to do is go online, and here's a picture of the Massachusetts Secretary of State's website for the Corporations Division. You go in there and you do a search on the entity name. If the entity name doesn't pop up, you can grab it. You can buy it right then and there. Now, if you buy it right then and there, you're paying $500. Well, maybe you're not sure. Geez, maybe I shouldn't go out and spend the $500. What happens if the deal never closes? I just wasted $500. So what you're going to do in that case is you're going to reserve a name. So instead of going out there and buying it, you're just for 60 days, you're going to reserve the name, and that's only going to cost you, as you can see here in Massachusetts, you fill out an application of reservation of the name, and then you pay $30. All right, so then you've reserved the name, and nobody else can take that name. All right, the thing that you want to be aware of is if you have several different companies and they're all similarly named. Let's say Manish LLC, and then Manish wants to go and he wants to start a new company called Manish One LLC. He owns the name in Massachusetts for Manish LLC. If he walked up to the window at the Secretary of State's office and said, I want to reserve the name Manish One LLC, the guy is probably going to initially reject that name because it is so similar to another name. But because Manish is the guy who owns the similar name, he can include a letter with his application stating that he gives permission for Manish One LLC to use a name similar to Manish LLC. So if you're trying to keep your naming conventions all very similar, make sure that when you go to apply online, you have that type, or when you go to apply, you have that letter written by you giving you permission to use that similar name. You'll see that come up quite a bit if you have Hogwarts Phase 1 LLC and then Hogwarts Phase 2 LLC. You'll have to have that letter when you go to apply for Phase 2. All right, so next thing you're going to do once you get the name, of course, is you're going to go and get your employee identification number, your EIN number, your tax ID. That is so simple. The IRS has made this incredibly easy for you. You're going to go in there and you're going to get the EIN number online, fill out the form, and call it a day. Now you've got the EIN number. They actually email it right to you. Make sure you save that form when you get it. And then you go back to the state and you go back and you register the LLC with the tax ID number. And because you need the tax ID number to register it with the state, and boom, you have just set up your LLC. Congratulations, you are now legal from the government standpoint, but you need to have other things in place in order to run this company the correct way, and also not only to run things the right way, but also to make sure that you don't do anything that will allow them to pierce that corporate veil. Here's the form, and remember, this is here in Massachusetts, and in every state, when you go to set up an LLC, what you're filing with the state is the certificate of organization. Okay, that's what it's called when you organize a limited liability company. When you do a corporation, it's articles of it's either articles of incorporation or articles of organization, depending upon what state you're in. So it's a different name. So remember, when you're talking about a limited liability company, it's certificate of organization. I want to talk a little bit more about nomenclature here right now. It's important that you understand the terms of the limited liability company. And let me tell you why I'm such a stickler for this. There's my dad. Actually, I just lost my screen here. Here's my dad. You may have seen this picture before. This is my dad. Just before he passed away. He's working in his hospital bed. But take a look at the T-shirt behind him, and this is the way my father was. I'm silently correcting your grammar. We got him this T-shirt because the guy was always correcting your grammar. We had to speak perfectly in our house, or he would be all over us. And he didn't hesitate to tell somebody if they were speaking incorrectly. We had, this is Mass General, which is part of the Harvard Medical School. We had a Harvard medical doctor come in, and he's telling my dad he's going to put in his pacemaker, and we're going to give you less options than we had before. And when we heard this world-renowned physician tell my father that he had less options, the three siblings, myself, my sister, my brother, all looked at each other like, "Oh no, here it comes." And sure enough, my 82-year-old father said, "Fewer options." And the doctor looks at me like, "What? I'm sorry, what?" And we're all like, he just corrected your English. It's fewer options. It's not less options." And the doctor's like, "Oh, okay. I'm sorry." So that is, it's with that background of how I grew up. I'm going to stress, if you're a student of mine, we are going to get this right. I don't want to hear any of you speak incorrectly in regards to limited liability companies. Here's what I mean. It's articles of organization. Is that what we use to start a limited liability company? No, it's a certificate of organization. And so in a limited liability company, do we have stockholders? No, we have members. Don't let me hear you talk about the stockholders in a limited liability company. They don't exist. How about stock? Do we have stock in a limited liability company? The answer is no. We have membership interest. And this is key. I hear people say this all the time, and I can understand why, but you got to get the nomenclature correct. It's you buy into a membership interest. You own a percentage of a membership interest in that limited liability company. You do not own stock. Corporate bylaws. You've all heard about the corporate bylaws. Those are the bylaws that run a corporation. Is that what we have in a limited liability company? No, we have what's called an operating agreement, and this is key. And we're going to delve deeper into this operating agreement today. But this is the document that governs a limited liability company. Okay? How about dividends? Do we pay dividends in a limited liability company? No. We pay distributions, and make sure you understand that you don't pay a dividend. What's a dividend on this limited liability company? No, it's what is the distribution on it. Now, what are some of the benefits to a limited liability company? We've already talked about. Hold on a second. I'm going to fix my screen here. I took a little. Somehow I lost the sidebar here that tells me if we have questions. Don't want to miss that. Go back here. What are some of the benefits to a limited liability company? We talked about the tax benefits, the pass-through. That means, like, for instance, I own a limited liability company up in New Hampshire. I own it with my siblings. We are just cleaning the property out, the company out of cash right now at the end of the year. So we are now making distributions to the siblings that are all members of that limited liability company. And it comes into us personally and then is taxed at our personal rate. The limited liability company is not taxed the same way it works with a partnership. It's a pass-through entity. Now, the other thing is that it's very easy to operate and maintain a limited liability company. There are two ways that you can do it, a member-controlled or a manager-controlled. I'm going to dig down a little bit deeper into that when we get into the operating agreement section. Now, you can also design the company any way you want, all right? This provision, look here what it says. Unless otherwise provided for in the operating agreement, you will see those words many times in an operating agreement. In other words, if the operating agreement is silent towards a particular aspect of operating a business, then it's entirely up to the manager or the members to determine how that situation will be resolved. So when you will see this particular provision in operating agreements many times, and when you do, it's providing the members or the manager with a lot of leeway as to how they can run that particular business. All right. So that's the beautiful thing about the LLC. It's so freeing, so to speak. But let's take a look at the key elements of an operating agreement, just so that you have the basic understanding of how it works. Now, in the resources and archives section, I have, I think, a sample operating agreement. Folks, it's a sample. It may not work for you. And sometimes, depending upon how you've made your offer on the deal, we may need to structure the operating agreement in a particular way to solve whatever solution you had in that offer. So don't just grab that template that's on the resources and archives and think that's going to be the solution to everyone's problem. You've really got to understand what you did on this offer and see if you need to cultivate or modify or manipulate the operating agreement to solve whatever offer you made. Now, you'll see exactly, I'm going to do some examples at the end of this class, and you'll see exactly what I mean by that. So typically in the very beginning, maybe Article 1 of an operating agreement are the definitions. I want you to read them. When you get them, read them and understand what they are, understand who they apply to, and I'm telling you, if you get different operating agreements from different people, the definitions will change. I just went through a nice operating agreement the other day. You had things in there. Oh man, as a matter of fact, I happen to have it right here. You got things in there with definitions of a divorcing spouse. And you think, why would that be in there? Well, that goes to how closely held a limited liability company actually is. We have to talk about what happens to a person's membership interest in the event of their death, divorce, disability, all those types of things. So that is all spelled out in the operating agreement, and you can find these types of things in the first place in the definition section of the operating agreement. Now, next thing you want to look at is the formation. It'll say exactly right at the beginning where this LLC is being formed, what state. I have had this question so many times, and I go through it, and I try to determine which state, which area is the best place to do business in. And I hear people talking about all different benefits to different areas. Let me lay some real life situations on you, okay? Massachusetts is $500 to form an LLC. Michigan, I think it was about $125 or $175. So if you got 10 LLCs, you're going to be better off just forming them in a state that costs less money. But here's what happens. If I form the LLC here in Massachusetts, and then I go out and I buy a property in Michigan, I still have to file a foreign entities fee with the state of Michigan. I have to let them know that I am a foreign entity, I'm a Massachusetts LLC, and I'm coming into their state to do business. They're going to charge me a fee for that. So it's not like, well, I'm just going to this one state to avoid a fee. You know what? They'll get you. Every state will get you sooner or later. Massachusetts just happens to be more sooner than later. So the question then becomes, what other reasons why would you choose to do business in a particular state? Now, I've heard people talk about Nevada and Wyoming. Okay, I got a question here. Let me just jump on this question. And Andrew, I don't think you missed it. Do you set up various operating agreements for each transaction / LLC, or just with your general partners? No. So what you're going to do is every time you go to buy a property, that property, if it's a separate raising of money, that's its own individual limited liability company, you're going to set that one up separately. Now, what I talked about before is the series LLC. You can have one parent LLC, and every time you go to buy a property, each one of those properties below it that you're going to be the sponsor of will be the sister LLC, will have its own limited liability protection, but they will all have the same tax ID number. So that is how you would set up these entities one by one. Each one would have its own protection. So let's see here. So the question becomes, which state should you form in? I've heard people say things about Nevada and Wyoming, that it's a great place where you can hide. You can, register and set up your LLC in Nevada and or Wyoming, and they don't ask for personal information about you when you set it up. So you can really, if you're looking to hide behind an LLC where nobody can find you, people have said that Wyoming is one of the best states to do that. Okay, great. Whatever reason you have for doing it that way, that's entirely up to you. But let's look at it from a practical standpoint. I'm setting up this real estate investment management business, Manish LLC. Now, I am going out there to buy properties all over the country. And when I buy those properties all around the country, I am going to set up an LLC for that particular property. Where should I set up that LLC for that property? Well, one of the reasons why I'm setting up this LLC is so that I can control where I get sued. I want to know where the state is that you have to sue me in and what type of law I can use in that particular state. So it becomes an issue of a choice of forum and a choice of law. That means that if Manish is here in Massachusetts and he goes to buy a property in Texas and he goes out to raise $1 million, he will create what I would have done. He would create an LLC for Texas Property LLC, and it will be a Massachusetts LLC. So everyone that comes to Manish to invest their money will sign off on an operating agreement that says, if you sue me, you have to sue me here in Massachusetts. And if you sue me, we have to use Massachusetts law. Why? Well, because I'm here in Massachusetts. My lawyers are here in Massachusetts. The courthouse is right down the street from me. And if you're going to sue me, I want to make it as easy as possible to handle. So I am going to set up these LLCs in my own backyard. So that is something you want to take into consideration when you're determining where to form your LLC. Why would you form it in Texas? Well, that's where the property is. Yeah, that's true. And if you look at some of these other documents, like your bank documents, the bank documents will say something to the effect that all lawsuits and all court filings will be done in the jurisdiction of where the property is located. Okay, fine. That's your bank documents saying that. You're not the bank. You have control over where you can have all of your legal actions taken. And, it's so much easier if you do it right in your own backyard. Okay, what's a single purpose entity? This is one of the benefits to a limited liability company, is you set the business up for one purpose. I am setting up the Texas Property LLC for the sole purpose of owning the Texas property. Once I sell that Texas property, this LLC has no other reason to exist. And so you're going to see that the first time you're going to see this on there is is when you go to fill out the form to get your tax ID number with the IRS. It's going to ask you, what is the purpose of this particular LLC? And that's where you see the single purpose entity. Now, as I said, we are having this discussion regarding an LLC that you are setting up for the property. Well, in that case, you're always going to check the box that says it's a single purpose entity, because that's exactly what it is. You'll also hear the terminology in SPE. That's what it means, a single purpose entity. That's what we're doing here. We're doing it for one and one time only to run this particular property. All right. Now, question is, how is the company managed? This is another question that you're going to see when you fill out the form with the IRS. And it basically comes down to two options. It's a member controlled or a manager controlled LLC. Now, if it's a member controlled, you can only have one member. You can have one member of the LLC, and it could be you. And if that's the case, well, then it's a member controlled. You can set it up as just one person. You could have multiple members and still be a member controlled LLC. But in that particular case, you're essentially running your company by committee. Everybody has to vote off on certain things that are what are called requiring consent. Make sure that when you read your operating agreement, make sure that when you read your operating agreement and you read the definitions, you read the definition of the word consent, because that's a very, very important word when you're looking at an operating agreement. It determines under what circumstances do we need to get approval from other people in order to act. So if it's a member-controlled LLC and you've got a bunch of members, well, you're going to be all voting together on how to make this thing operate. So think about this for a second, folks. If you are setting this company up and you're going out to raise private money and you're going out to run this property on behalf of your investors, do you want a member-controlled LLC where everybody gets to vote on how the LLC is being operated? I would venture to say your answer is going to be no. All right, so another thing that you can have is what's called a manager-controlled LLC. So what happens is the members elect or vote for a manager or choose a manager. And the manager does not have to be a member. The manager can be somebody who is a W-2 employee, or it could be a member. But the thing is that the manager is the one that makes all the determinations on the property and how the business is being run. So here's typically how you would set up your company. All the members are members of the LLC, but we separate them into separate classes. And we're going to get more into classes in a moment. But one class will be the class of membership that gets to vote on the manager and who the manager is to run the LLC. Who do you think is going to be the one sole member of that class that gets to determine who runs the property? If you're looking in the mirror right now and you see him, you're right. You, as the sponsor of this deal, will be the determining person in the membership, in the member class, that chooses the manager so that you control how that LLC is run. You don't want all of your investors voting on who the manager is. You want to control that whole thing for yourself. Now, I one time got into oh my gosh, I was arguing with this CPA one time where he was trying to tell me that an LLC cannot have a president or a CEO. That's not how LLCs operate. They cannot have a president or they cannot have a chief executive officer. And I said, what are you talking about? Of course they can. He goes, no. It's a member-controlled or a manager-controlled. That's it. That's how an LLC is run. And I said, no, that's not how an LLC is run. The manager or the members can vote to have a president or CEO or vice president of the limited liability company. It is still a manager-controlled or a member-controlled LLC, but for the day-to-day operations, they've decided that they're going to choose a president who's going to run the company. And there's nothing wrong with that. This gets back to the ease and the simplicity and the beauty of running a limited liability company. It's so easy to come up with solutions for how you want to do things in the business. You know, you could be sitting around, well, I don't want to run it. Well, you run it. Well, let's hire somebody to run it. Great. What are we going to call him? I don't know. Why don't we call him a president? Well, we can't call him a president. Sure we can. We're the members. We can call him whatever we want. And that's how you make your decisions. Well, hopefully a little bit better than that, but that's how you decide how you want to run the company. Okay. Now, let's take a look at the classes of membership, and this is where you really get to be Shakespeare, as I say here. This is where you get to be as creative as you want. All right, this is where you decide how you want this business to operate. And the thing about it is that it's very, you got a clean slate when you get started. So when you're, and one of the reasons why I'm teaching this to you now is that when you're drafting your letters of intent and you're coming up with some funky ideas, your funky concepts about how you want this deal to go down, you've also got to be thinking in your mind, how can I create this solution in this offer in an operating agreement so that everybody can live by it? And so you're always thinking in your mind, I've got to, I've solved this problem over here, but once I solve that problem, I've got to be able to pencil it out and make sure that it works from a legal standpoint in my operating agreement. So let's talk about the different classes of members and different ways you can do it. But here's one of the beauties about a limited liability company. It has to do with the rights of the members. All right. In every limited liability company membership interest, the person holding that membership interest has two rights. They have economic rights and they have management rights. And these rights can be separated. You can sell off your economic rights, but keep your management rights. So how does that operate? Well, that just means that if Manish goes out and sells his economic rights to me, anytime there's a distribution or he sells the company, makes money, or there's a tax event, I get the benefit of the economic interest. I get the distribution. I get the cash. Manish doesn't get anything because he sold it to me. He gave it to me. Now, I, though, because I only own the economic rights, I can't vote on anything. I can't tell anybody how to run the company. I have to sit back on the sidelines and let whoever it is that runs that property, runs that company, run the company, and I just hope that they do it correctly and I make some money off of it. So you can separate the two rights, the economic, the management rights, depending upon how you want the deal structured. Now, I'm going to show you an example of how we did that on a particular property that we own and why it was the right thing to do. And I'm going to show you another way that it was done in a moment that wasn't so great. So make sure you understand exactly what we're talking about. So let's talk about the different classes of membership. Let's think about it from a practical standpoint. You're going out there to buy this property and you've raised $1 million. You haven't put a dime in. You're the sponsor of the deal. You want to control the property and you want to, pay a distribution to every member. How do you set that company up? You set it up by first creating Class A. Class A members are people who have been given a percentage ownership of the entire membership interest of the property, a percentage of that. And in this particular case, because we're talking about you, Class A members did not make a capital contribution. They didn't put any of their own cash into the deal. So in that case, if we write the operating agreement so that nobody receives a distribution until anyone who has made a capital contribution gets their money back, Class A members aren't going to see a dime until all that money is paid back, which some investors like to see. But if you're the Class A guy and you're looking to make some money on this deal, you don't want to have that provision in there. You want to make sure that when the distributions are paid, they're paid to every class member based upon their percentage ownership. So Class A members have zero capital contribution, but they have a percentage ownership of the company. And here's where it gets fun. Only Class A members are allowed to vote for the manager of the property. Only Class A members can choose who runs the LLC. They have that voting right, and it's clearly written out in the operating agreement. All right, that's how we solve that problem. Now, we've just raised $1 million, and $1 million has come into this LLC, but we have to ask the question or answer the question, what did that $1 million buy? Well, what that $1 million bought was a Class B interest. And let's say, for instance, if Class A was 30% and we only needed $1 million to close this deal, Class B now owns 70% of the deal for $1 million. But what does Class B get with that? Well, what Class B gets is the economic distributions, the membership interest that gives them the economic distributions of any gains on that property. So that's how Class B works. Does Class B get to vote on who runs the property? Technically, according to the operating agreement, no. But Class B could have a say in how the property is being run by statute if the manager has been screwing up badly. So here's what I mean. The operating agreement is what the courts are going to look to first. If it doesn't clearly state what you're supposed to do and there's a dispute, the court could then turn and look at the Limited Liability Act of that particular jurisdiction and what it says in relation to a manager acting inappropriately. So even though you are the manager on the property and you're running this thing as you see fit and you think it's the right way to go, if you're acting in a non-fiduciary capacity, because you do have a fiduciary responsibility to all the investors, if you're acting in a non-fiduciary responsibility, the Class B investors could sue you and they could come in and get control of the property. And in that case, the courts look to what the act says, what the statute says, as it relates to this particular problem. So the operating agreement is what everybody turns to first, but there's always a body of law over and above the operating agreement that protects the Class B investors. So you can't just run this thing as you see fit. I mean, you bought this property, you say you're going to do great things to it, and you turned it into a cat house. Well, the Class B investors are going to be like, hey, that's not what we signed up for. We want you removed as the manager. Well, you can't do that. I own all the Class A and I have all the rights. Like, no, you've breached your fiduciary responsibility. We're going to come after you legally. And they can do that based upon the statute. Okay, so those are the things you need to think about when you're running a limited liability company. You have a fiduciary responsibility to the class, to all the members in the limited liability company. All right, so let me know if anybody has any questions on that. I know it kind of got a little bit heavy there. Now, Class C. Well, who's Class C? Well, you know, Class C could be a special class. Maybe we made an offer and we promised somebody something in the offer, and we have to figure out a way to solve that promise. And the only way we can do it is in the form of a third class or multiple classes that speak to that particular promise that we made. Let me give you an example of what I mean. Let's say, for instance, that the seller has agreed to take back a second mortgage, but the bank is not going to allow it. Sound familiar? You've probably heard me talk about this all the time. So in that particular case, how do we solve that problem? Our letter of intent was drafted. It had a seller financing provision in it. The seller accepted it, and now the bank is saying, no, you can't do it. How are we going to make that deal happen? What we do in that particular case is we essentially create those three classes. We make Class A be us, the sponsor of the deal. We make Class B be the cash investors, the people who showed up with $1 million. And then we make Class C the seller. So the seller is now buying into, essentially, for the value of that second mortgage or whatever it was that we're ultimately going to create. The seller is going to get a membership interest in the LLC as a Class C member. I'm just calling it Class C because that's the next letter. But he is now the Class C member, and he's the only one in this class. So what do we do? How do we solve that problem of the second mortgage with a Class C membership interest in a limited liability company? Well, what we do is we make sure that we draft the operating agreement in such a way that the Class C membership interest looks, acts, and feels just like a second mortgage. Now, how does that work? How can you do that? Well, think about what a second mortgage offers. A second mortgage offers an interest rate. We're going to pay a fixed interest rate on that principal. It's going to be for a fixed term. After a certain amount of time, I get to cash in on that second mortgage. And then we also say, remember, a second mortgage or a mortgage has foreclosure rights. It has protections. It sits above, in the form of debt, it sits above the equity holders. So how do we draft a class of membership in an LLC that looks, acts, and feels like a second mortgage? Well, we say, okay, Class C membership is equal to $50,000, and we're going to we're going to pay 5% interest on $50,000. It's going to be paid once per year, and for the 7-year term that we have, the Class C membership exists, and at the end of the 7-year term, the LLC will cut a check to the Class C members for $50,000. And here's the clincher. There's a provision in there that says no other member gets paid a distribution from the LLC until all the interest and principal, if we're paying principal, has been paid to the Class C member. So essentially what we've said here is that we're not going to get paid unless this guy gets paid. And that is how he's receiving that protection like he would on a second mortgage, but it's not tied to the property. It's tied to the limited liability company. All right, so do you see how that works? We had a problem. We had a problem with a second mortgage. Bank comes back and says you got a problem. How do we solve it? We solve it by creating another class of membership in the LLC. The problem is solved because we're not burdening the property. We're essentially burdening the LLC. Now, I always get this next question. Well, do we show that to the bank? And the answer is, yeah, of course you show that to the bank. Why wouldn't you show that to the bank? The bank is going to want to see the operating agreement anyway. The bank just doesn't want to have anyone with foreclosure rights behind them. They know that they're selling this property to you. They want to make sure you don't lose this property because you're the guy that they took to the dance. So they don't want to have anybody with foreclosure rights behind them. And that's why, in this particular case, the foreclosure rights don't exist. It's all in the form of a limited liability company class, separate class. So that is one way that we solve a particular problem. Now, and the solution to this problem has to be understood at the letter of intent stage. So when you are making an offer for seller financing, you have to put it into the document in such a way that you know when it comes time to solve this problem, it's going to be solved in the drafting of an operating agreement with the limited liability company that owns the property. So that's why I said early on, all of these things, I'm teaching you how a limited liability company operates so that you can be ready for it when you're making the offer to the seller. Now, let's take a couple of examples of some real life examples here. What would you do if the seller recommends that you purchase the LLC and not the fee simple interest? All right. What exactly do I mean here? What I mean here is, and I've seen this come up a couple of times recently, as a matter of fact, where the seller owns the property, and the seller owns the property in a limited liability company. And the seller says, hey, I'm in Texas, and Texas is a non-disclosure state. And if we transfer this, they could find out, by giving you a fee simple interest, the assessor's office could find out that, you bought it and changed hands, and he's going to go up in the taxes. So why don't you buy the membership interest on the limited liability company from me, and I'll just transfer it over to you, and therefore the real estate never changed hands. It's still owned by the same LLC. Now that's one example of why you would do it this way. I just had another situation where the it had to do with let's see, that example was taxes. There was another one that had to do with a government entity. They didn't want the government entity to know that the property was changing hands, so the offer was made by the seller to sell him the membership interest and not the fee simple interest. Okay, this could work. We actually did it on one particular deal that we did, and it's worked out beautifully. But the problem is that when you purchase the membership interest of a limited liability company, you're getting the assets, but you're also getting the liabilities. So let me ask you something. What are the liabilities of this LLC? Well, I don't know. Well, you did the due diligence in the property, didn't you? Yeah, I did, but I didn't go and do a UCC search on the LLC. I didn't go to find out how many credit cards this guy has open in the name of that LLC. I don't know how many, personal loans this guy's taken out in the name of the LLC. I don't know how this guy has obligated the LLC to borrow money. So you have no idea what the liabilities are on this LLC. So therefore, what are you going to do? You could be buying a whole lot of debt that you just don't even know about when all you wanted was the fee simple interest in the property. So that's one of the risks you face when you're talking about buying the limited liability company. Now, one of the benefits to it is that we can come up with if the seller is remaining in the deal with some form of seller financing, and it turns out that there are these unknown liabilities, you can write the document such that any unknown liabilities that creep up after the closing date will be removed or reduced. Well, they will go towards reducing the ownership interest of the seller. So instead of the guy, taking back a second for $250,000, and you come to find out the guy's got, $200,000 that he owes to somebody else in the name of the LLC, well, you just knocked off $200,000 off of what you owe him because you're not going to pay that. So the fact is, or you're going to have to pay it, but you're not going to pay him twice. So that is one of the ways that you can protect yourself. What happens if it's you don't have enough money? That's a risk that you take. What happens if, one of the ways you say, if the guy seems like kind of a snake, you can protect yourself. Any liabilities that creep up after the closing date, will be multiplied by 3, and that amount will be removed from the outstanding amount owed to the seller. You can create a punitive situation for him, penalize him for not disclosing all the liabilities. So there are different ways that you can be creative when you're just looking at buying the LLC. But I'll tell you something, folks, every time I have had that scenario, well, I can't say every time because I actually did it myself and it worked out beautifully, but most of the time when I hear somebody looking to just buy the LLC and not the actual real estate, it's always to try to get out of doing something that they're going to be obligated to do anyway. And you got to ask yourself the question, is that really the type of person I want to be getting into bed with? Because this guy's going to be your partner, or could potentially be your partner going forward. So always ask yourself the question, why is this guy offering me the LLC? Why can't he just sell me the fee simple interest in the property and I'll go out and start my own LLC from scratch, nice and fresh, day one, everything is clear sailing. So always ask yourself the question. Keep that in mind as you go through the acquisition process. Okay. All right, what is this one? You want to take over the control of the property, but you want the seller to remain on the loan. Okay, this is exactly the case that we had down in Tennessee. What happened was there was a bunch of properties. There were 170 mortgages on it was a 220 unit property portfolio. There were about 170 single family mortgages on all the homes. And if we changed ownership, if we took more than 50% control, that was a qualifying event in the loan documents, and it would have to be that would be what's called an EOD, an event of default with the loan documents. And in that particular case, you'd have to notify the bank. The new buyer would have to be underwritten for 170 loans, and it would have just been a disaster. So what we decided to do is we decided to separate the rights but deliver the poison pill. What does that mean? So we were going to buy 60% of this property. And what we decided to do is the seller sold us 60% of the economic rights to the property. And then the seller kept the management rights. And the management rights meant, by him keeping the management rights, it meant that he didn't have to go back to the bank and have to re-underwrite the entire deal for 170 single-family homes. So we've now bifurcated the deal. We've separated the membership interest from the economic interests. We get our 60%, which is what we had originally agreed to in the document, and they now own 100% of the management rights. But wait a minute here. Part of what we originally signed up for is we wanted a control of this property. We wanted to say, hey, we own 60%, so therefore, by us coming to the table with cash, we get control of the property. But if they keep 100% of the management rights, they have control of the property. So what we ended up doing is we drafted a management agreement that said, you are going to choose us to manage the property. We will control the property, and we will manage it on a day-to-day basis. And here's the contract. You sign off on it, and now we run the property. But remember, folks, they own 100% of the management rights. If they own 100% of the management rights, and all we have is a management contract with them, can't they fire us? And the answer is yes, they can, because they have 100% of the management rights. So how do we protect against that? The poison pill. And the poison pill is a document that they have signed off on, allowing the transfer of the 60% of the management rights to us in the event that they do something to in violation of the terms of the agreement. It's not dated. We have the document. All we have to do is fill in the date, submit it. We now own the full 60% of the membership interest, both the economic and the management rights. We control the property. They're out. So that way we were able to solve the problem with the bank by making sure that the management rights didn't change. The bank knew all about it. They liked it. They liked the deal. They liked the way we came up with it. We got the economic rights, which is what we wanted, and control, which is what we wanted. And now it has been operating perfectly fine for the last 2 years under that agreement. But we always have that poison pill. If somebody gets a little uppity, if somebody steps out of line, we slap that down on the table and we take over full ownership. Does that trigger the event? Absolutely. Is that going to impact the guys on the hook right now negatively? Absolutely. So they are going to not want anything to happen to this deal either. So that's a way that we were able to create a solution to a problem by using the operating agreement, by being the Shakespeare, by having that clean slate and being able to draft it any way we want. So that's another example of how that works. Now, how do you sell your membership interest? All right, folks, very simply, read the rule book and follow it to a T. This goes back to the beginning of the conversation about piercing the corporate veil. The operating agreement is the rule book. Follow it to a T. I mean, there's actually oh man, I was just involved in a situation. It's I'm not directly involved, thankfully, but what happened was a particular investor. Somebody came to and said, hey, I found this great piece of land, but I don't have any money. You want to buy this land? And the guy says, oh, yeah, that $2 million, it's worth $6 million. I'll buy it. And the guy says, okay, well, cut me in for something. So we'll be partners on it. I'll buy the property, and we'll be 50-50 partners. Pretty generous, right? All on a handshake. Okay, no problem. These guys are old friends, and they get along well. So what happens is, as far as the operating agreement is concerned, the cash buyer is all the bank sees. And actually it was finance, so there's a bank involved. But the guy who put up the cash to get the deal done with the credit, all the bank sees is his name. He's a good borrower, great credit risk, deep pockets, and the bank likes him. So the operating agreement has his name on it. What about the guy, the handshake? Let's call him the handshake guy. What does he own? Well, technically, he owns nothing. He owns nothing, and just a promise to pay of some sort. Maybe down the future things get worked out. Well, what happened was the handshake guy was involved in another deal, and he owed money on the other deal. So in order to get that other deal taken care of, he took his membership interest in the land and transferred it to this other person that he owed money to. The other person filed bankruptcy. The other person files bankruptcy and he lists his assets. What do you think shows up on the asset? The land. Well, all of a sudden, my client gets notification that he is being dragged into bankruptcy court because the bankruptcy trustee wants to liquidate the land in order to pay off debts. Well, wait a minute here. I don't even know who this guy is. It's filing bankruptcy. How the heck did he get, or how is he possibly claiming that he has a membership interest in this land? Find me any paper trail that shows this guy has the membership interest in the land. And the fact of the matter is that my client's going to be able to get out of it very easily. He's going to turn to the handshake guy and say, hey, what the heck are you doing? You can't do that. This guy was essentially going out there and selling multiple interests in that land in order to get out of debt, in order to maybe raise some cash. So what happens is it turns out this guy can't claim that membership interest in the land because in the operating agreement, it clearly shows you how you're supposed to transfer a membership interest, and those rules were never followed. It's a voidable contract, a voidable transaction, which it will be, and there's nothing that the bankruptcy trustee can do. He doesn't own it. They have to go back to the handshake guy and say, hey, you owe us something else. The footnote of this story is that the guy who filed bankruptcy was found in his truck about an hour from his home in a field in the freezing cold in his pajamas and a bathrobe with one slipper and a shotgun to his chest. And they've ruled out suicide. So this story goes a little bit deeper. I'll keep you informed, you guys, on some of the Monday coaching calls. Ask me about it. I'll let you know what's going on with it. I don't think anything's really moving that quickly with it, but it's a very interesting story. So that's really it. That's all I want to teach you today about the limited liability companies. If you have questions about it, type them in right now. You got me live, and that is it. I want you folks basically run through it here. You gotta hire a lawyer to draft the operating agreement the correct way. You can use my template. You can see how it works, but you've got to make sure that it complies with local laws, and you got to make sure that it complies with exactly what you're looking to do. Beautiful thing about a limited liability company is that it is a clean slate. You can design it any way you want. That's what I love about it. People come to me and say, and that's, I get this quite a bit. It's kind of become one of my specialties here is solving problems, transactional problems, by using an LLC and an operating agreement. And basically the way I do it is I listen to what the problem is, and I just think, how do I get to the solution? And along that pathway, what does the document have to say to get me from point A to point B? And I think it's a lot of fun. It's like a logic problem. It's a word problem. And so, if you have any of those types of situations, hey, let's talk. That's what I'm here for. That's what I'm here to help you guys. And I will give you direction as to how to do it, and I'll send you on your way to your local counsel. Right? And that way you'll all be protected. So, all right, that is it for today. And I will be talking to many of you on Monday. I hope this was helpful. And otherwise, everybody have a great day, and I'll talk to you soon.